And so the most important thing about law, of course, is the impartial, fair and impartial manner. Also, citizens can resolve conflicts and disputes through courts, tribunal and legal procedures, and individual can seek justice, hold wrongdoers accountable for their actions, okay, and promoting trust and confidence in the legal system. Okay, so yes, besides trade, besides addressing public concerns, so really, it really affects our, when we are, when international counterparts, our friends from international look at the country itself, whether how progressive you are or how developed you are. Usually, law is one of the what we call mark, one of the sort of like a measurement for this progressiveness of a country. That's why we are marked with transparency. We are marked with our values, social norms, and what direction we are. The better the legislation, the better the judicial systems, the better the enforcement for the rule of law, the more fairer it is, the more just it is. We are being measured. Our country is being measured. The progressiveness and the development is measured with this particular systems called rule of law. And of course, like people say, oh, you civilize people or not? These are actually also marked by how much you follow the rule. So that's why some places you feel like it's not safe, because people are not abiding to the rule, or the enforcement is very weak. And of course, when the enforcement is very weak, people are not abiding to the rules, and there will be a lot of social disorder and chaos and all that. So you don't want to do businesses with people like that. You don't want to work in countries like that. And international do not want to do international friends do not want, international other countries do not want to trade with you because you don't have a proper systems of rule. Like many, many years back when we were in Vietnam, like once about 20 years back, it was very, very undeveloped, and then we call it undeveloped because rule can change, regulations and systems from the authorities and government can change overnight. So no one dares to do any business with them, you see. So that's why they remain very closed, they remain very undeveloped, we call it, and the mindset of people are very low. We say that, they are very barbaric, they are very uncivilized, that's what the word we use. So these are all measured with law. So you can see the importance of law, Okay, so there's a law covers many areas, basically, We have criminal laws, we have civil laws, we have constitutional laws, we have administrative law, international law, contract laws. So there's many areas of laws, basically. So contract laws, basically, this is what we're going to be covering in our subject in this particular course. So it's about the legal rights between the contractual party when we are providing our services or our goods to another party. So in the construction industry, for example, if we a client hire a contractor to build his project, the consultant is the engineer. They are appointed as the advisor through the privacy of the contract. So contract means that it recognizes the legal rights of the client, the legal rights of the contractor, the roles that they are playing, and what is their obligations, that relationship, the legal relationship. So it recognizes. So contract law will recognize that relationship between two parties. So our job as engineers or professional architects or QSs, we will actually, the most common area of law that is applicable to us will be contract law. Every project is a contract, and therefore you need to abide by the contract because the system, the constitutions actually have the Contract Acts, and the Contract Acts actually tells you how do you draft a contract, what are the elements of contract. I think you've covered that already. its elements of contract like offer, acceptance, consideration, intention to create a legal relation, who can contract, what is mistake, what is misrepresentation, what is what are the other elements that makes your contract recognized in the eyes of Malaysia. So basically, you have the constitution that already sets down the fundamental rules of forming a contract through the Contract Acts, okay, and that forms the contract law. Then after that, you will every individual or every business in the country will base on this contract acts to actually create their contract. So you must follow back this contract act. You see, so of course we don't really draft our contract all the time, but lawyers can help us to draft. They are trained to do that. So then when the contract is there, it spells out that the two parties or three parties, roles, responsibilities, and what are the punishments or enforcements. It could be termination, it could be suspension, it could be damage. You have to pay liquidated damage. So there's many ways of redressing your grievances. So if somebody didn't follow, somebody did not behave accordingly, then the other party can actually come in and say that, you do me wrong. So therefore, in this contract, we have this sort of measures or this sort of methods for you to compensate me, for example, the me who is being wronged by your actions. So you didn't do your responsibility. So what can I do? So again, it falls back to justice. It falls back to a very just society, reflecting how, how we can resolve dispute and conflicts and give us protection against abuse of power, discrimination, and injustice, and provide a way to seek compensation or redress or improvements for the wrongs that is being done to us in the contract. Okay, so that is basically contract acts. I think you've gone through that quite extensively. I think you have a whole class on contract acts, and of course, so that is contract law, which is very much what engineers do day in, day out. They have to be the contract administrator. They have to be the one to understand, sometimes draft the contract, sometimes do not draft the contract, but read the contract, at least understand the contract so that you can execute or you can administer the contract accordingly. And of course, many contracts in our industry are being put up in the standard form of contract format. The standard form of contract basically is like written by authoritative bodies like government authorized bodies such as JKR, such as Public Works Department, such as CIDB, such as Pertubuhan Architect Malaysia, such as IEM, Institute of Engineers Malaysia, which is the rights given by the Board of Engineers to actually draft this particular standard form. So they actually have this standard clauses, standard way for standard projects, for normal project that falls within the normal functioning projects. I mean, normal function in a project, like not very specialties or whatever. So their contract, this is like a one-size-fits-all, standard form of contract is like a one-size-fits-all t-shirt. So they give you that general conditions of contract that actually goes through very, very standard things that would normally happen on most construction project or most construction site or most engineering project. So they have that standard form. Some companies, they draft their own standard form and it's applicable to their own project because they have very standard projects. Like SED, they will have very, very standard projects that is dealing with dams, energy supplies and all that. So they will have already got a template basically, and that template is a standard form of contract. So you need to understand. But this standard form of contract, from standard form to standard form, the issues that they cover will be pretty much standard. And you will, if you need to add in or take out or anything, you cannot just simply do that. You need to actually seek legal advice or go back to the Contract Acts to see whether you're taking out things that is not supposed to take out or adding things that you're not supposed to add in, because everything is fundamentally based on the Contract Acts. Okay? So I think it is something that we are really, covering, just to recap your